Okay, we're going to be talking tonight about how to use a power of attorney. It's not so much what is a power of attorney, but supposing that you actually have one of these things, not that you're the person who signed it creating the thing as what we call the principal, but you're now the agent. And what should an agent be doing, and perhaps maybe what should an agent not be doing if they're entrusted to manage somebody's affairs for them. We have both financial powers of attorney and healthcare powers of attorney in Pennsylvania, so you may be serving under a document that covers both of those topics. You may be serving under two different documents that one covers healthcare, one covers financial, or you may just be doing one or the other. We also have in Pennsylvania, much less commonly, mental health powers of attorney. They're used predominantly for people who have a long history of mental illness, and they deal primarily with some of the treatment options that are used in mental health and allowing agents to intervene to help people manage their mental treatment. But they have a shelf life to them, so they kind of go, they're not like Twinkies and they don't last forever. In the case of financial powers of attorney and healthcare powers of attorney, once they are signed, unless they're revoked or the person who signed it dies, they pretty much stay in effect. Even if the law changes, the old documents are at least historically, have always been grandfathered in and continue to be valid, although maybe certain provisions of them are no longer effective because of changes in the law. But with mental health, if you happen to have a mental health care power of attorney that you're working with, you want to be very careful about when it was signed so that it's not expired. You'll need to have the person go back and re-execute it. So what I want to cover at the beginning is understanding your authority to act. What are you allowed to do? What are you not allowed to do? Documenting your actions, accounting for your actions, and learning about the issues that agents routinely encounter during the term of their service. Understanding your authority to act it really requires one thing that very few people ever actually seem to do. It's very hurtful to me because I draft powers of attorney for a living. No one reads them. They don't read them. I mean, I think they'll try. The guy got like 4 sentences in, my head hurt, my eyes rolled back in my head, I threw up a little bit, I couldn't keep going. It was very hard to read. I promise you, they are actually written in English, they're written in words that you have used every day of your life. We just link the words in combinations you might not have seen before, and we use incredibly long sentences. They're, the grammarians in your life who taught you English in junior high maybe would probably be very upset with lawyers when they see our 98-word sentences with 16 semicolons in them and things. But you should start by looking at the document and reading through it. They're not all written the same. And most people assume, I think, that all powers of attorney are the same. And they really aren't. They're like my little children. I craft them for each of my clients. They're largely the same, but I will include from time to time provisions in some that I don't include in others, and it's done by design. I'm trying to address things that are of specific importance to the person I'm representing when I prepare the document. And so I want people who are acting as agents to read through them and make sure that they kind of understand what they're allowed to do and what they're not allowed to do. The example that I gave you on the slide here is that some powers of attorney for financial matters will contain gifting clauses. There are different kinds of gifting clauses. Even within my office, there are several attorneys who practice in the estates field, and we all have different preferences for the kind of gifting powers we like to include. The most common gifting power that I see in documents written by other lawyers are limited gifting powers. They'll say, my agent shall have the power to make limited gifts. And that turns out to be a statutorily defined term of art. It means you can make a gift to an individual that cannot exceed $14,000 per year per person. It's a tie-in to the federal gift tax law, which says if you're going to make a gift in excess of $14,000 to somebody, you're going to have to file a gift tax return to report that gift. You're probably not going to pay gift tax, but the IRS likes to keep score on gifts over $14,000, and so they want you to file the return. If they had the amount lower every Christmas, the IRS would get bombarded with gift tax returns, and they don't want to know about the crock pot that you gave your mother. So you don't have to file a gift tax return to report the gift of the crock pot, unless you bought her a $14,000 crock pot. But you can also have broad gifting powers, a gifting power where the amount of the gift is not limited. So if I have $300,000 and I have a broad gifting power, my agent could give away $300,000 of my assets. But you have to say that specifically in the document, that the power to make the gift is not limited by the amount. There's no cap on that. It may define who are permissible recipients of these gifts. So, for example, the ones that I draft, it's usually a spouse, if there is one. It's usually children. It's maybe spouses of children, grandchildren and their spouses, other individuals who might be identified in the person's will or a trust that they set up. Those are the people I would generally expect would be the normal recipients of gifts. Would not be the creepy guy from across the street who suddenly befriended your mother in a time when her senility was a little bit greater than before. We don't really want him to be able to receive a gift. We don't want him to use a power of attorney to give himself that money. So you may want to take a look at that kind of thing. There may be a provision in there that says, as the agent, you can name a successor to yourself. If you suddenly are unable to serve, you could pick your successor. Now, normally you'd go back to the person who gave you the power and say, hey, I can't do this job anymore. You better pick somebody else. But if they're in a position at that time where they can't name an agent, they're incapacitated at that point in their lives. It would be nice if, recognizing you're not going to be able to do it, and recognizing that they can no longer make that decision for themselves, that you have the power to appoint someone to act in your place as your successor. Again, most powers of attorney don't seem to have that provision in it. But some do. I think the better written ones do. Mine do. And I'm certainly not the only one. I looked at one today written by another attorney in town, and good for him. He had a power to appoint a successor agent in there. He also had a limited gifting power, which put him on my naughty list because limited gifting powers are not usually very effective. They are used predominantly for very, very wealthy people who are trying to avoid the federal estate tax by giving away their money before they die so that they don't have as much to pay estate tax on at the time of their deaths, and they're trying to avoid gift tax at the same time. So they're using that $14,000 free clause. But if I have somebody with only $300,000, let's say a husband and wife, they own a house in Shillington worth $200,000, they've got $300,000 in savings spread out between IRAs and things like that, and my husband is going to be going into a nursing home, and my wife is a little worried about how much that might cost and how much of their savings might be depleted, I might suggest to her it'd be a good idea to take their home that's jointly owned and retitle it into her name alone. Well, I can't do that if he's unable to sign the deed. I can't move the title without his signature. So if he can't sign, I need someone to sign on his behalf. And if she's limited to the size of the gift she's giving herself, which would be half the value of the home, to only $14,000, she can't use that gifting power to take my advice unless the house happens to be only worth $28,000, which there's some houses in Reading that are only worth $28,000, but not too many in Shillington fit that category. So, in that particular instance, my wife client cannot follow my recommendation to put the house into her name and take it out of joint names. And I won't go into why I would give her that advice tonight. If we get done tonight and you're really interested, we'll go buy a beer and I'll tell you. But that's just an example when I would use a broad gifting power for someone who didn't necessarily have a whole lot of money. They certainly weren't real wealthy. When you act, it's important to understand what your authority is. And it's laid out in that document. That's why it's so important to read it. It tells you what your instructions are. It's not much different than a cake recipe. It just tells you, how to make a cake. When you read the recipe, the power of attorney is a recipe for what are you allowed to do. And they're generally pretty broad. Pretty much anything that we could think of, because we don't know what the person might need. So we pretty well give the agent all the power we can think of. But overarching those specific powers, the power to go to the bank and open and close accounts and sign checks and pay bills and make investments and sell real estate, all those different specific powers, overarching all of that, though, you're supposed to do things that are in keeping with the person who appointed you, with their expectations. You shouldn't be doing things that they wouldn't like or that they wouldn't expect you to be doing. So that becomes kind of the pole star in the law. If someone's criticizing you for what you did as an agent under a power of attorney, one of the first things they're going to ask you, was this something that the person appointing you, a parent, for example, would have expected you to do and would have wanted you to do? That doesn't mean you always have to make decisions that they agree with, but it means that in general, you shouldn't be, I wouldn't have expected my son, if I named him as my agent, to retitle my car into his name and drive off to live in Fresno in my car. That would be a little unexpected. And that's the first clue that what he did is not exactly cool. And so he's going to be potentially liable for that boneheaded decision. That's why it's so important to talk to the person that appointed you and find out what it is they might think you should be doing for them. In many cases, if they're still competent, they are really good sources of information. Make your job a lot easier. They can tell you, for example, that, I have Comcast where I get my cable. I don't use Service Electric or some other company for my cable, and I get my cable bill, on or about the 10th of the month, and it's roughly this much money. Well, that would kind of help to know. So I can kind of keep an eye out for the Comcast bill if I'm expected to start paying that. And if they like watching, the NFL channel, I better not change their subscription around so that they drop the NFL channel. That wouldn't be nice.